One of the basic expectations of an employment relationship is that the employee will act with fidelity and good faith. That's pretty general. There are a whole range of ways a person might not be acting with fidelity and good faith. If an employee was stealing trade secrets and selling them to an opponent, if an employee was being paid off by a rival company to sabotage their employer's work, that would not be fidelity and good faith. In this case, Blyth Chemicals manufactured a range of chemicals, mostly out of happy substances like arsenic and lead, and most of those chemicals were used on fruit farms. It makes you shudder. Mr. Bushnell managed the Blyth Chemicals works. There seems to have been no complaint about the quality of his work. However, he later formed another company to manufacture white lead, which was used to make white paint. That company did not intend to make any products which would compete with Blyth Chemicals. Still, it doesn't seem unreasonable for Blyth Chemicals to have been worried. Their concern was that the new company might expand its product range and compete with them, in which case Mr. Bushnell could simply leave and take a bunch of clients with him. Bushnell proposed to give a written undertaking that the new company would not compete with Blyth or Blyth could obtain damages. Negotiations broke down and the company sacked Mr. Bushnell, who sued for unfair dismissal. The thing is, at the time he was dismissed, he hadn't done anything wrong. His work for Blyth Chemicals was satisfactory, and the new company was only making white lead for paint. Could they sack him in anticipation of something that might happen? The court said no. Justices Dixon and McTiernan said conduct incompatible with the fulfilment of an employee's duty, or which involves a conflict between his interest and his duty to his employer, or impedes the faithful performance of his obligations, or is destructive of the necessary confidence between employer and employee, is a ground of dismissal. But the conduct of the employee must itself involve the incompatibility, conflict, or impediment, or be destructive of the confidence. It is not enough that ground for uneasiness as to its future conduct arises. From this case, we confirm the duty of fidelity and good faith, but these must actually be broken before the employee can be dismissed.